You said earlier, Mr. Stewart, it's not a limit on the amount that a candidate can spend or even loan. And I want to focus on that, or even loan, because it would seem to me that the law puts the candidate to a choice of spending your own money for a loan above $250,000 or foregoing repayment of any amount above 250, and foregoing any repayment for an amount above $250,000. So the choice is to spend that without any possibility of getting it back, or not spending it at all. And that seems to be, therefore, a chill on your ability to loan your campaign money. Why is that not right?
I think the third option is you can loan the campaign as much money as you want, and you can get full repayment as long as the loan is repaid with pre-election funds.
Well, suppose, sorry to interrupt, but it's a close election. You're emptying the coffers. It's down to the wire. There are no pre-election funds left. That's how close elections work. You spend it all a lot of times, or come close to it. So you have to rely on post-election funds. In that instance, the candidate coming down in the last few days is quite a bit chilled from using his or her own resources above $250,000, because there's no possibility of repayment under this statute, even in $2,900 chunks.
I think the two things, I first concede your premise that there will be situations in which, very close to the election, the candidate will be faced with a choice of either limiting the size of the loan he makes or being willing to eat a portion of it. I think the two things I would say are, first, Congress has the objective that it has of reducing candidates' reliance on outside contributors for financial well-being, and Congress can be concerned about candidates who put themselves in their position where, in order to be repaid in full, they have to solicit post-election contributions from donors who know that the candidate has won and know that the donor is dependent on new money in order to be made whole. The second thing I would say is, even if you thought the statute would be unconstitutional as applied to that particular scenario, it wouldn't be a basis for accepting the as-applied challenge here, because the campaign here made the loan for an entirely different purpose. And one
more, sorry, but why allow the $2,900 repayments up to the $250,000 cap then? Aren't those people who give those $2,900 post-election contributions also triggering the same corruption problem that happens with the person who happens to give the $2,900 when the $250 cap has been exceeded?
I guess the two things I'd say are closely related to what I said before. The first is, if the loan is small and the candidate is very confident of it being repaid, then no individual donor will have particular leverage over the candidate. And the second is...
Well, time out there. It's $2,900 from each person. And the theory has to be that each person's $2,900 triggers, in a post-election contribution, triggers some corruption appearance problem. I don't see why that's different where your $2,900 comes in the wall before or after you exceed the 250 cap.
I agree, and as we said in the opening brief, we think Congress constitutionally could have eliminated all use of post-election contributions to repay candidate loans. Indeed, I think Congress constitutionally could forbid post-election contributions altogether, and could say any money that is donated after one election has to be directed to the next one. And the question is just, can Congress attempt to balance competing interests, or can it focus on the very worst manifestations of the behavior without having the statute held unconstitutional?
Thank you.
Justice Barrett.